Council versus resident, more Supreme Court action expected. Independents call for de-escalation, gang says no. At the snowy Monaro Regional Council Extraordinary Meeting on the 3rd of July 2025, Councillors Williamson and Reuben moved a motion seeking to lift an unreasonable complainant conduct restriction placed on a resident who has since initiated Supreme Court proceedings against the Council. The motion also proposed the formation of a Council committee to oversee future unreasonable complainant conduct applications and requested quarterly reporting on all active unreasonable complainant conduct restrictions. Motion content, as per Agenda Item 7.1. Part A. Remove the unreasonable complainant conduct restriction placed on the Supreme Court applicant. Part B. Create a committee to oversee future unreasonable complainant conduct restrictions. Part C. Require confidential quarterly reports on all active unreasonable complainant conducts. Motivation and context. Councillor Williamson explained that the motion was driven not necessarily because he believed the unreasonable complainant conduct was unjustified in itself, but due to governance concerns. Specifically, the General Manager Stephen Dunshee, who is personally named as the first defendant in the Supreme Court matter, declared a conflict of interest and left the meeting. Williamson highlighted that the decision to refer the matter to Council's insurer for litigation may have been made by someone with a declared conflict, raising questions about procedural fairness and transparency. He argued that simply lifting the unreasonable complainant conduct may prompt the resident to withdraw the legal challenge, potentially saving significant legal costs and reputational damage to the Council. Key points from the meeting? Mayor Hanna and several councillors, including Summers and Higgins, opposed the motion, arguing that debating the matter could put the Council in a legally vulnerable position and possibly affect its insurance coverage. The Chief Strategy Officer, David Rawlings, confirmed the insurer had no objection to the motion itself, and even acknowledged that removing the unreasonable complainant conduct might lead to the case being withdrawn, though without certainty. The motion was defeated. Only Councillor Williamson and Rose voted in favor. The rest, 8 councillors, voted against. No formal debate occurred against the motion, though concerns about governance, legal risk, and procedural protocol were voiced. Analysis. This episode encapsulates several chronic governance issues within the snowy Monaro Regional Council. 1. Poor governance and risk aversion. Rather than seizing a practical opportunity to resolve the legal matter efficiently, by lifting a potentially outdated restriction, the majority opted for procedural rigidity, despite credible risk of escalating legal costs and reputational harm. 2. Conflicted leadership. The General Manager's recusal due to being personally named in the case is not trivial. It raises deeper issues about institutional conflicts of interest and whether objectivity and accountability are possible under current structures. Number 3. Policy paralysis. Council is still operating under an older unreasonable complainant conduct policy that has not been updated, despite newer guidance being available. As Councillor Williamson noted, the Council's failure to adapt or act has now resulted in the courts becoming a necessary forum for residents to seek justice. 4. Chilling effect on residents. The individual in question has already won a court action in the Land and Environment Court earlier in 2025, yet rather than engaging constructively, Council responded by maintaining an unreasonable complainant conduct restriction. This has created the perception that the Council uses unreasonable complainant conduct and to silence dissent, instead of a genuine risk management tool. 5. Political dynamics at play. The vote split yet again follows known factional lines, with independent councillors, Williamson and Rose, supporting transparency and de-escalation, while the so-called gang, largely Labour-aligned, shut down the proposal with minimal scrutiny or justification. Conclusion. The refusal to lift a potentially unlawful, unreasonable complainant conduct restriction, despite the clear governance benefits of doing so, suggests the snowy Monaro Regional Council is more committed to defensiveness than problem-solving. The cost of this approach will likely be borne by ratepayers, who now face footing the bill for a Supreme Court battle that could have been avoided. More concerning, however, is the message sent to the broader community. If you challenge Council decisions, no matter how valid your concerns, you may face administrative silencing rather than fair engagement.
We have no leave of absence. Do we have any conflict of interest?
Through you, Mr. Mayor, yes, I declare a significant non-pecuniary interest in the matter, as I am named personally as the first defendant in the legal actions that's referenced in the motion and the background information. And on that basis, I will declare that interest and vacate the meeting.
Thank you. We're moving on to notice of motion 7.1, unreasonable complaint conduct. Councillor Williamson, your motion. Do I have a seconder? Councillor Rose, thank you. Councillor Williamson, you have your 5 minutes.
Well, thank you, Mr. Mayor. So I brought this motion after a discussion with Councillor Rose, and it's not because I have a view that Part A of the motion is actually the correct thing for Council to decide. But we've brought this motion because we think it is a matter for Council to decide as to whether or not we wish to defend the matter that's gone before the Supreme Court or not. And to bring about that decision, we've put forward the motion as written there. As our General Manager has in fact just declared a serious conflict of interest and left the meeting, that's actually the reason why I've brought this motion, because as I understand it, we have referred this matter to our insurer, who now is litigating the matter in the Supreme Court. That can't be a choice made by someone who has a conflict of interest. It's poor governance. And that's the reason I've brought the matter to us tonight with the motion that's before us. It seems logical to me that we can avoid all the effort and challenge around this by simply removing the code of conduct that has been applied against the individual who has brought the matter before the court. If the code of conduct is removed, there's no matter to go before the court.
Sorry, point of order. There is no code of conduct on any of these people in the UCC.
Yes.
Code of conduct or the restrictions around the
unreasonable complainant conduct.
For
some reason I'm thinking about code of conduct tonight.
As has been mentioned, is before the court. Claims made were things that are covered under our insurance policy. So as we do, we refer the matter to our insurer to deal with matters that are covered by our insurance. That's a standard practice. So that matter is now then, because as with all insurance policies, and you've had a briefing on this, we are indemnified by the insurer, and part of that indemnification is that they proceed with the matter as they see fit. So that is going through that process. Councillors, I would advise to be cautious about anything you may say, for if you say things that would lead to detrimental impacts on that potential case, that could be used against us. That may impact on our insurance coverage. So that you do need to be cautious in that regards. So in terms of the policy, and it's mentioned there in the notes, this effectively is breaching your policy before you adopted it, because the what's here is separate to the policy process for how UCCs are put into place and managed, for example. So in terms of...
My concerns are this whole little show is placing us in a very deleterious position for anything we might be saying. The whole fact that we're having a discussion could be deleterious to the council, the courthouse, and to the court, and to our insurance coverage. I think it should be voided immediately.
If I could just finish, because
I beg your pardon, I thought you had.
did talk with our insurers about this in terms of the actual motion put there to see if they had concerns about it. The actual motion they did not have concerns about per se. It's up to council if it chose to make that decision. But we do need to be cautious.
Can I just follow up? Did they offer any views to what the decision that occurs would have any influence?
They only expressed the opinion that it may lead to the applicant withdrawing their claim, and so that may resolve the case. But it is may, it's not.
If no one wants to, if no one wants to debate it, then we can put the motion. That's exactly right. So thank you. Does anyone want to speak against? No. Thank you. There's no against, so there's no debate. I'll put the motion. All those in favour? Councillor Rose and Councillor Williamson. All those against? Councillor Summers, Councillor Higgins, Councillor Stewart, Councillor Elliott, Councillor Rooney, Councillor Davis, Councillor Hopkins, Councillor Hannah. Thank you. Motion's lost.